Hello and welcome to the Port Migration YouTube channel. If you're new here, we're thrilled to see you, and if you're a returning viewer, thank you for your continued support. We really appreciate it. My name is Joanna Hill. I'm a registered migration agent and I'm here to guide you through the ins and outs of Australian visa applications. In today's video, we're diving into two recent updates for the Subclass 482 Temporary Skill Shortage Visa. So whether you're a current 482 visa holder, a 482 visa applicant, or an employer using the 482 visa to recruit and retain skilled workers in hard to staff industries and locations, this video is for you. So these changes, effective from July 2024, are significant and they could impact your visa journey. The key is to stay informed. But remember, while this video provides general information, Australian migration law is complex and ever evolving, so for personalised advice tailored to your unique situation and circumstances, be sure to contact us through the links in the description. Before we get started, don't forget to like and subscribe to our channel. We're proud to have this growing community with over 1,000 subscribers. We're here to make the visa application process as simple and stress-free for applicants and employers as possible. So no matter what your industry is, whether it's hospitality, construction, education, agriculture, manufacturing, whatever it is, reach out if you need expert assistance with your Australian work visa application. Now, if you're looking for more information, check out our blog article, How Do I Apply for an Australian Work Visa? It's a great resource to kickstart your research and explore your visa options. So the links, including those to our blog, our contact information, and how to book a free call with one of our MARA registered migration agents, the links are in the description below. A free call is a really great first step if you're looking for professional guidance as you navigate the work visa application process. So today, let's have a look at two recent changes that relate to the Subclass 482 Temporary Skill Shortage Visa. Now, the Subclass 482 Temporary Skill Shortage Visa is designed to enable employers to sponsor workers to fill gaps in hard-to-staff occupations. The 482 visa has three streams: the medium-term, short-term, and labour agreement streams. Visas are generally granted for up to 2 or up to 4 years, and apart from some narrow exceptions, the visa only allows you to work in your nominated occupation for your nominated employer. The first Subclass 482 visa change we're going to talk about is the increase to the TSMIT, the Temporary Skilled Migration Income Threshold. Now, I started work as a registered migration agent in 2015, and if you're an employer who has been sponsoring workers for that long, you will know that the TSMIT has been set at $53,900 for a very long time. It was increased to $70,000 and has now been increased to $73,150 from the 1st of July 2024. So Subclass 482 visa applications lodged from the 1st of July 2024 need to meet this increased TSMIT rate of $73,150, as well as meeting market salary rate requirements. The TSMIT will also now be indexed annually with the CPI. This is really important to keep in mind when you're deciding wages for sponsored employees and doing the required advertising to meet the application requirements. Again, reach out through the links in the description for assistance with the visa application and sponsorship process if you're lodging applications for Subclass 482 visas. Now, check out our video also, which I'll link here, for more information about recent visa price increases from the 1st of July 2024. So, the second change I'm going to talk about is the change to Visa Condition 8107, 8607 and 8608. These visa condition changes from the 1st of July 2024 are a big deal for 457, 482 and 494 visa holders. If you have a current Australian visa, you can check your visa grant notice to see what conditions are attached to your visa. If you're not sure of the current implication of these conditions, VEVO is a great place to look. You can do a VEVO check of your visa status, and when you do this, you'll also receive current information about the visa conditions attached to your visa. This is really useful if there have been changes to visa conditions since your visa was granted. Now, VEVO is obviously also really useful for employers, as the onus is on you to make sure the people you're employing have work rights. Now, Conditions 8107, 8607 and 8608 have been updated, which is impacting 482, 494 and anyone who still holds a 457 visa. These changes affect these visa conditions which relate to the time that a visa holder has to find a new sponsoring employer if they stop working for their current sponsoring employer. Now, we know this happens. People change employers while they're holding a visa. It's particularly common in some industries. Hospitality is one, and also for qualified and experienced trade workers in mining and construction, the current worker shortage means that there are more opportunities for changing employers than there have been in the past. Now, I recorded a video recently about changes to Trades Recognition Australia's skills assessments for construction trades workers. I'll link it here. Might be interesting if that applies to you. So, here's what you need to know about these recent visa condition changes. These conditions now have significantly increased work flexibility. Visa holders now have up to 180 days at a time and up to 365 days total across their entire visa grant period to support themselves while seeking new sponsorship if their previous sponsored work ceases. This is a big change from previously, where visa holders couldn't work to support themselves while they were seeking a new sponsor. Now, it's important to note also that this can include work outside their most recently approved nomination and occupation. So let's take a look at the description of Condition 8607. This is from a VEVO check that I did for a client yesterday, and I'll include a screenshot so you can take a look. So Condition 8607 must only work in nominated occupation. You must work only in the occupation nominated in your most recent Subclass 482 Temporary Skill Shortage visa application. You cannot work in a different occupation unless you apply for and are granted a new temporary skill shortage visa. Unless an exemption applies, you can only work for the business that nominated you if your visa was granted in the labour agreement stream, medium or short-term stream, and your sponsor is an overseas business. If your visa was granted in the medium or short-term stream and your sponsor is an Australian business, you can only work for the sponsor that nominated you or an associated entity of your sponsor. If you want to change your employer, your new proposed employer must get a nomination approved before you can start work for them. If your employment with your sponsor ends, you can stop working or work outside of the above conditions for a limited time, up to 180 days in a single period, and up to 365 days in total across the period your visa is granted for. These time periods start from the 1st of July 2024. They do not include any earlier periods of time when you stopped work under the condition in place before that date. You can work for other businesses if the occupation is specified by the Minister in the relevant instrument, or if your employment is ending and you are serving out a notice period. You must start work within 90 days of arriving in Australia if you were outside Australia when your visa was granted, or of being granted your visa if you were in Australia when the visa was granted. Now, the employer nomination requirements are an important part of this. If you're an employer sponsoring visa holders to work in your business, notification requirements are worth keeping in mind. If there are changes in employment, such as seeking sponsorship, ceasing sponsorship, or resignation, employers must notify Home Affairs within 28 days. So these visa conditions apply to both existing and new visa holders from July 1, 2024, with the 180 and 365 day periods being counted from this date. So the VEVO check above was done for an existing 482 visa holder, but the description in their VEVO check reflects the new conditions. So the goal of these changes is to reduce employer exploitation of visa holders. And the impact is significant for both visa holders and employers. The change increases worker flexibility to move between employers and also gives impacted visa holders the means to support themselves as they do this. Keeping accurate records is going to be crucial for compliance when measuring the 180 and 365 day periods. Now, for more personalised advice on how these changes to subclass 482, 494 and 457 visa conditions might affect your situation, be sure to book an appointment through our website. Whether you're an employer sponsoring workers or a visa holder yourself, we can guide you through the implication of these updates and how they relate to your situation. Migration changes can be complex. Staying informed and up to date is really important, especially with the more significant changes that are on the horizon, like the upcoming Skills in Demand visa, which is being introduced as part of the Australian Government's migration strategy. If you found this video helpful, don't forget to subscribe to our YouTube channel. Join our growing community. We have over 1,000 subscribers. They're staying ahead of the curve on Australian work visas by staying informed and up to date. You can find all the relevant links, including how to contact us, in the description below. Thanks for tuning into this Subclass 482 visa update. We're here to help you navigate the changes. Have a great day and see you in the next video.